Good morning, Mr. Shea.
Good morning, Your Honors. Richard Shea for the defendant Lee Perkins. The defendant was tried in 2000 for the 1990 rape and murder of Sandra Francis. He was, as I said, he was tried in January of 2000. The jury was, on the murder charge, was instructed only on theory of premeditation. It convicted him of premeditated murder. It also convicted him of aggravated rape. Thereafter, the parties briefed the appeal, as well as a denial of a first new trial motion on the issue of him taking Elavil during the trial. And that was about to be heard when it came to my attention for the first time that there had been audio taping of the attorney-client conversations in this trial. Thereafter, the appeal was stayed and a second new trial motion was filed. The trial judge was Judge Barton, had retired, and it ultimately was assigned to Justice McAvoy, who had an evidentiary hearing in March of 2006. I think it's important to begin my argument by noting that the defendant is entitled to a very strict standard of review by this court of this issue, that the issue involves the constitutional right to counsel. And as the judge below found, and as the case law in the Downey cases has indicated, the agreement by an attorney to wear a body microphone during trial, which is going to intercept his client communications, creates an actual conflict of interest. It's analogous to him having Lion Television as his second client at the trial. With
All of this was agreed to by your client, correct?
No, Judge, that's the ultimate issue, and I intend to argue that there was no consent by the defendant, that because this was a waiver of the right to counsel, the Commonwealth must show beyond a reasonable doubt that the waiver was intelligent and voluntary.
It's a waiver of the right to counsel?
Yes.
Is that what?
Well, of unconflicted counsel.
Unconflicted counsel, yes.
Right. So if it's an actual conflict, you have to show the waiver of the conflict, right?
If there's the defendant shows an actual conflict.
The Commonwealth has to show a waiver of the conflict.
That's
that
correct.
is an actual conflict because of the taping.
Yes, I have shown that it's an actual conflict because of the taping, and my position is at that point the burden shifts to the Commonwealth to prove under the constitutional standard that it was beyond a reasonable doubt an intelligent and voluntary waiver.
Well, excuse me, Justice Arlen, go ahead.
Do you dispute that prior to trial, the attorney filed a motion to exclude the cameras? Trial was on January 10th, 2000. On January 7th, the attorney filed a motion to exclude cameras dated January 5th. You don't dispute that?
I don't dispute that, no.
You don't dispute that prior to trial, counsel called the chief judge of the trial court to confirm that the court had approved the filming?
That's correct.
You don't dispute that the attorney instructed the defendant to write down anything he wished to communicate while the court was in session so that they could discuss it privately in lockup?
Yes, that the judge credited that testimony of the attorney that conversation occurred in either November or December before the January trial began.
Well, you know, the judge concluded that counsel zealously and diligently protected the defendant's rights by informing the defendant in detail about the production and all of the potential disadvantages to the defendant. Do you dispute that?
Yes, I do.
And how so?
How so? Because the conflict of interest is broader than simply saying, talk to me, and we can get around this by this microphone by talking to me in the lockup or writing it down on a legal pad. As is evident from the videotape of this trial, the television company chose for two of the most dramatic moments of its half-hour production, attorney-client conversations in which obviously neither Mr. Perkins nor his attorney thought a bit about the fact that there was a live microphone recording their conversations.
Well, the judge said that counsel cautioned the defendant that because Lyon would record everything, these recordings could be used against him in a subsequent proceeding. You dispute that?
He did tell him that, but what he didn't tell him also was that you had not only a videotape running, but audio sound man listening in on all of this, and that any time during the trial, any of the raw video footage or the statements of the audio guy who had overheard the conversations could have been disclosed to third parties, including the prosecution or the police or any other person.
Did the defendant sign a consent form?
He signed nothing. It was not tendered to him. And I think it's important that I emphasize that there's a rule of this court, 119C, I believe it is, that requires the judge to take precautions in the courtroom. And one of the precautions is, without any qualification, that there is not supposed to be filming or audio taping of attorney-client conversations. It's right in the rule. The rule was not brought to the defendant would be the last one in the courtroom to know that this rule existed. The attorneys on both sides did not bring it to the judge's attention, and the judge sua sponte did not raise this. And as you have noted, this is something that had been in the works since the preceding summer or fall through the chief trial judge's office. And this was going on in Suffolk Superior courtrooms. It went on at least 3 of them. And it was going on in the district court. And so this was not a sudden thing where people should have been unprepared. But in fact, it does appear that everyone was unprepared for the judge to address in the courtroom the fact that this taping violation on its face violated the rule.
But counsel, if your complaint is that it's a violation of a court rule, we would then look to see whether there was a showing of harm, whether there had been some harm. And I can't see that that's been shown.
Yes, I agree.
If it's a constitutional right here, a conflicted counsel, actual conflict, then I don't think harm has to be shown. So the rule violation, I don't think is going to get you very far.
I think the rule violation shows that the court has put into a rule a prophylactic procedure to protect criminal defendants in this kind of a situation, where you've got to realize this defendant came out of prison where he had been serving a sentence and was brought into the courtroom, and the trial began. And essentially, his rights were not inquired into at all by the trial judge. And what you have to rely upon is strictly the attorney testifying that in the months preceding the trial, including as much as a month before the trial, he discussed the microphone arrangement. And he told the defendant the microphone, he didn't have to wear the microphone, the client didn't have to wear the microphone. As it turned out, they didn't mic up the clients. And he told him he could turn the mic off when he wanted to, and it was up to him. And in the words of the attorney, the client did not object. It's a pretty thin waiver of the issue based upon his not objecting to what's being presented to him. I think it's absolutely essential that the court take a look at what went on after those initial attorney-client conferences at the prison, what went on beginning with Mr. Tipton filing the motion in limine on January 5th. The matter was before the judge on Friday, January 7th, just kind of a conference in anticipation of trial beginning the next Monday. And he mentioned to the attorneys, I understand that you've filed a motion in limine. I'm told that this television production is not going to be shown in the United States anytime soon. It's for British television. It's not going to be shown
2
contemporaneous.
years or something, is that right?
Pardon me?
Was it 2 years or something?
Something that came up at one. Someone said that at some point. You know, it would be 2 years. In fact, it may not have. It may have been 2 years when it showed up in the front line. The BBC program was boiled down into a short frontline program, and the Perkins case didn't make it into the front line.
Mr. Shea, what was the basis, I don't have it, I don't think, here with me, of the denial of the motion on January 10th?
It was the judge stated in his discretion he denies the motion.
With
No.
no reasons?
That's it.
This was for the videotaping, right?
For the videotape, for the television production. I think it's important to note the defendant, Mr. Tipp, what I was getting at on January 7th in the preliminary hearing, the judge said they're not going to be showing it in the United States anytime soon. Mr. Tipton said, I know. I told that to the defendant. He told me to go ahead anyway, and I filed the motion.
Go ahead with the motion.
To get the motion eliminate to get the camera thing out, the whole production out of the courtroom. He wasn't saying you can tape my attorney-client privileges on audio tape. He wanted the whole production out.
I thought his real concern was the video, though.
That's what the attorney kept emphasizing. I would submit in a self-justifying way, trying to limit what the client was really concerned with was the video. But if you read the motion in limine, paragraph 6 of the attorney's affidavit in the motion in limine, you will see that he says that the client is concerned that he does not want his image or the facts of his case spread out in the television. And the concern of that is not just because he's on trial today in Suffolk Superior Court and some enemy of his in prison is going to see his picture in the Boston Globe. It's he didn't want his trial for rape and murder to be portrayed on television where people wherever could watch it, including his mother. And that was another specific statement in the attorney's argument to the court, that the defendant's mother, he did not want her to be subjected to having the television program showing up a couple of years down the line.
What do you say about the fact that the court credited the attorney's testimony? Wasn't that a credibility assessment that the judge made, which
yes.
which we're all stuck with?
I agree with you, and I take comfort in the rule that because this is a constitutional question, the judge's subsidiary findings only should be given deference, that when this court is looking at the ultimate factual findings and rulings of law, namely whether or not the client gave knowing and voluntary consent, then you give a de novo review. And what I'm saying is
do we accept the judge's statement? This court credits the attorney's testimony that he had extensive conversations with the defendant about the production and the microphones.
Yes, and you can go back and read the transcript where the attorney testified to that, and I don't say that I think the judge credited what he testified, and I can't say it's clearly erroneous. But what I do say is that you have to look at the undisputed documentary evidence of what was said in court on January 7th and on January 10th. The defendant, and through his motion in limine, this was the defendant speaking through his attorney clearly, he did not want the camera operation going on in the courtroom. And it's disingenuous to say, well, he really qualifiedly didn't care about his attorney having his conversations with the attorney being overheard. It would appear that at least there is a reasonable doubt that between the time he talked with Mr. Tipton in December of 1999 and the beginning of trial in January, the defendant dug his heels in and didn't want anything to do with this. And Mr. Tipton can testify what he perceived the defendant to be saying to him in the late fall of 1999, but we have the record before the judge in which you have only the unqualified opposition of the defendant to the taping, and you have a judge who simply denies the motion put the cameras out without any inquiry into the prophylactic rule, which should have, it's quite a detailed rule, not just attorney-client conversations. He did not, should have been something that should have been sua sponte inquired into to ensure that the defendant's rights were being protected.
And I haven't read that transcript yet, but did the judge in 2000 articulate that he was really focusing on the filming, or was he really, when he denied the motion, or was he dealing with everything? In other words, because you know, at that point in time, I mean, it would not have probably been appropriate to deny the cameras themselves. You would agree with that? Quite apart from the TV show. But I mean,
agree
cameras
he could have,
themselves could
yes,
not have been kept out.
Right. I think the judge, that's what the judge was saying in the exercise of my discretion. I'm going to allow this to go on. But where he didn't get to the more important issue of the fact that everybody, according to Mr. Tipton, everybody in the courtroom was mic'd up, the court personnel. And he didn't get into any inquiries about that to see if there was going to be some protections for the defendant. And mind you, the defendant was entirely silent during this. He could only speak through his attorney, who now is challenged with having had a conflict of interest. So the best evidence of the defendant's point of view is what was said on the record at the time of trial.
What about looking at the defendant's behavior during the trial?
Yes.
The judge also looked at his behavior and concluded that it was the equivalent of consent. The defendant engaged in one-on-one interviews.
My response to that is that when you look at the only way you can understand that is the defendant is filing this motion in limine at the outset saying, get the camera operation out of there. He wasn't planning to have an interview if they packed up and left. But the crucial thing is his trial was going to be on television now because his motion was denied. His case, the facts of his case, not just his image, was going to be broadcast. And Mr. Tipton said, at one point he said, Mr. Perkins wanted to get his side of the story out, and that's exactly what he did in one of these interviews that you'll see on the videotape.
But you can't have it both ways, can you?
This is 5 days. This is well into the trial when...
But doesn't that amount to consent?
No, the consent was... His consent was vitiated the day the judge denied the motion and told the cameras they could continue. After that, the defendant, what is the defendant to do? Leave the courtroom?
But he doesn't give an interview. Whatever he does, he doesn't give an interview.
I'm saying the reason is the cat is out of the bag at this point. The defendant is playing catch-up, trying to protect himself and justify himself because he knows this is going to be on television. But before the cat was out of the bag, he did not consent. And that's the crucial time frame. At the very beginning of trial, he was not consenting.
Mr. Scher, in that interview, in that interview, was he asked about attorney-client privilege communication?
Well, I don't think he was asked about attorney in that, but there was another staged camera event sometime later in the trial in which Mr. Tipton and Mr. Perkins are in a conference room talking about whether he should testify or not. And the camera, they were mic'd up and they were being videotaped for this television program, and it's in the television program. So that certainly, conceitedly, that certainly shows that he was willing to be taped at that point. But as I said, the damage is already done, and he's trying to protect the damage. I'd also say that it makes no difference that much is made of the parties and the judge in the case about the Boston Globe.
How is it a protection of the damage to give an interview?
He didn't want the trial in the television at all. Nobody would know about his case.
Did he say that in the interview? That he didn't want...
No, he filed a motion in limine to...
No,
and
but
his attorney stated in the motion in limine that the defendant did not want the facts of his case on television.
But he never stated that in the interview.
Well, the interview was just it's a couple of minutes of him justifying himself, and he reads the Bible at the conclusion of it.
Mr. Shea, if the parties hadn't been mic'd, I mean, the defendant, it seems to me, didn't have the ability to say to Lyon, you can't video or audio tape what goes on in the trial. I have to consent to being mic'd, but
Yes.
the rest of this, his concern was having this shown on TV, right?
That's right. And
That could have happened regardless, right?
That's not really a constitutional issue for him.
the constitutional issue, the question is what was his state of mind, and did he consent?
To the
Well,
mic.
I think
Did he
it's- I
consent
think
to
it's
having
fair.
his attorney have Lyon as his co-client? And I'm suggesting that the fact that he is trying to get Lyon out of the courtroom indicates that he was not consenting to that conflict of interest.
Did he at one point say he wanted to get paid for this, the defendant himself?
I think that was a Downey case.
Okay. Okay.
Thank you, Mr. Shea.
Okay, thank you.
Good morning.
Good morning, Your Honors. David McGowan, Assistant District Attorney for the Commonwealth. And with me this morning is John Zanini, also for the Commonwealth. The issue today is whether or not this defendant consented to the presence of a third party, in this case the Lyon production crew, to be present during attorney-client conversations. In this case, the record is clear that this client did consent to their presence, and their presence in the form of the wireless microphone that his attorney was wearing.
Mr. McCown, assuming, what's your, I mean, I've read the briefs, obviously, but the response to the claim that there's an actual conflict here?
My first argument is that there is no actual conflict. There is no tension between Attorney Tipton and any other interests that during this trial other than the zealous advocacy of his client, Lee Perkins. There is no tension for him to be drawn one way or the other, where some cases...
Well, why would a defense lawyer consent to having conversations with his client? Why would any lawyer consent to having a conversation with a client opened up to the public?
That's an excellent question because, as Attorney Tipton outlined for his client, there are a number of hazards with that. In this case, the attorney had already had a mistrial with Attorney Tipton as his attorney, and he said, if there is another mistrial and there's a subsequent proceeding, you know, Lee, all these statements that are made on the record can be used against you then. Are you sure you want to do this? He outlined all the consequences for his client, and his client still wanted to go ahead.
So what's the benefit of having the media involved in the attorney-client relationship if it's not for the client's benefit? Isn't it for the attorney's benefit? Here he is being exposed to the public, getting worldwide exposure for his defense skills. Isn't that what it comes down to?
I would argue it's not, Your Honor. I wouldn't argue Attorney Tipton did this for himself or any attorney would
But
do this.
the approach was clearly to Tipton, correct? The original approach was to Tipton.
Yes,
There was
originally,
no communication. Was there any communication between Lyon and the defendant?
there was not.
So everything is through Tipton.
Inappropriately so, as he was representing Mr. Perkins in this matter. And when originally approached...
No, I
when-
mean, there's absolutely no reason why, there are lots of cases where people who want to write books, write to the person, even if he's an attorney can't do that. But I think one of the problems here is who is Lyon dealing with? And Lyon's dealing with the attorney. And we don't know what Lyon said to the attorney. Do we?
Well, we don't know the exact words that were expressed to the attorney. We do know that Lyon approached Mr. Tipton and said, we're going to be taping, would like to interview both you and your client beforehand and throughout and other individuals over the course of this trial. Attorney Tipton then, to verify that, knowing that they hadn't even gone into a trial session yet, contacted the chief.
Yes, but in any event, as Justice Watchford has suggested, you can have cameras in the courtroom in this Commonwealth. They had every right. They had every right to, whether they had, who was giving permission to mic up court personnel. Were they court personnel mic'd up?
I don't believe court personnel was, just the
Okay, I misunderstood, Mr. Shea.
the prosecutor, the defense attorney, and then there were strategically placed microphones around the courtroom as there are each day. So,
Well, I don't know, I think, again, from Justice Botsford's point of view, strategically placed microphones, if they are going to pick up communications, between counsel or among counsel and defendants, a court would normally not permit that. Was there?
certainly, I understand the court would normally not permit that. There's no evidence in this record that those are the mics at issue.
Well, was court permission sought?
I believe yes, because Attorney Tipton contacted the Chief Justice of the Superior Court, and the Justice responded, yes, Lyon will be conducting these.
No, but Lyon can film. I mean, as I understood it, he contacted and then whoever the Chief Justice was at the time said, they are filming, yes, but that has nothing to do with, quote, strategically placed microphones.
Yes, the microphones at issue with respect to the record in this case is solely the microphone worn by Attorney Tipton. That's the only microphone that, from the record, picked up any kind of attorney-client conversations. And
what are your strongest points to the effect that the defendant consented to this?
well, as Your Honor pointed out, the one-on-one interviews. But with respect to his attorney's mic, when a Boston Globe still photographer came into the courtroom, the jury hadn't been brought in at this point. The defendant turned his back on the courtroom, his whole chair back, and sat down. Judge Barton stood up, was not happy with this behavior, took a brief recess, and took the Boston Globe cameraman back into his chambers. When he returned, he said he had excluded all photographers from the courtroom for the duration of the trial, because he didn't want the defendant claiming any kind of prejudice on appeal. In this case, the video picked up a conversation where the defendant said to his attorney, I just thought the PBS cameras were going to be here, not this cameraman. That indicates that he was comfortable with the videotapes, the Lyon production.
I mean, I think it's ambiguous about that. I mean, how much he was focusing on. I mean, clearly he didn't want his. I think we can agree that he didn't want his picture. Correct.
Correct.
But as I look at both I don't have the February 4 affidavit of Mr. Tipton, it's rather ambiguous about, the microphone.
It is, Your Honor. The affidavit is with respect to the videos, the production as a whole. I think when Attorney Tipton was testifying at the evidentiary hearing in his affidavits, he is referring to the microphones are included within his discussions with the client about the Lyon production itself and their involvement.
Well, here we have, at least in the 2000 affidavit, Tipton saying, it's my belief that transmittal of the defendant's image and any transmittal of the facts of this case in the media. Now, the media, of course, can cover, what's happening in an open court.
The situation originally for Attorney Tipton was to protect the defendant's safety from the threats allegedly made by other inmates. So he didn't want his photograph being disseminated within
or the facts.
Well, yes.
I mean,
he didn't want the crime he's being alleged with, presumably, to be knowledge among his colleagues.
If you have the voice without the image, of the defendant saying to his lawyer, yes, I did this, yes, I did that, no, I didn't, I wasn't there. I mean, doesn't that also run a risk of safety? If your concern is safety, because this all followed after he'd received threats, correct?
Excuse me, Your Honor?
The concern arose after he had received threats, correct? After the defendant.
Exactly.
Yeah.
Yes, and he transferred facilities at one point due to those threats, and so he didn't want that situation to arise again and have to move again if news of his current situation reached other inmates or those who were making these threats.
See, Mr. Nugent, I'm sorry to interrupt you. One of the problems here was there was no there was no hearing. I mean, there was no evidence taken on the motion for the retrial, right? Tipton wasn't.
Yes.
Oh, yes,
And
yes,
there
it
was-
was. In the evidentiary
okay,
hearing,
yes.
there were two
Okay.
witnesses, first being Attorney Tipton and then also the defendant, Lee Perkins. And that's where Judge McAvoy gets the testimony that she does credit, that Attorney Tipton had extensive discussions about this situation. He advised his client not to do the interviews, and the client still did the interviews. So Attorney Tipton, as Judge McAvoy noted, was meticulous in protecting or at least informing his client about all the possible consequences. And in the big picture, this could be a very unwise move, but it is his choice, not Attorney Tipton's, and he made that clear to his client, and his client chose to go forward. When the situation changed in the client's eyes, when there's a Boston Globe photographer there, he clearly had an ability to voice his opposition and did so. Judge Barton made the ruling to exclude the still photographers, and the defendant for the rest of the trial was very calm and apparently okay with that situation.
Mr. McGowan, I believe the judge also found that Attorney Tipton met with the defendant before trial, during lunch breaks, and after trial as well, in an effort.
In the afternoon?
In the afternoon, yeah, in an effort to communicate with him outside of the cameras.
Absolutely. And faced with his client consenting to his wearing a microphone, Attorney Tipton took precautionary steps to minimize any subsequent consequences of that decision. First, he suggested, as he does to all his clients, to use a pen and paper during the course of the trial so the jurors could never pick up what is being said. In this case, the defendant's own testimony at the evidentiary hearing, he did employ that strategy. And then, as Your Honor pointed out, Attorney Tipton did meet with the defendant down in lockup after every day's proceedings. And that's the testimony at the hearing. So Attorney Tipton, as noted in the judge's findings, took very precautionary steps, faced with his client's consent, to minimize any possible consequences, especially in light of the possibility of another mistrial.
The motion judge, I remember, addressed the defendant's objection to the Globe still photo reporter, or still photo camera. But I don't remember. Did the judge address the defendant's motion in limine?
The judge was juxtaposing the motion for the motion to eliminate, if I recall correctly, with the subsequent conduct and his reaction
Talking about Judge
to the present.
Judge
Yes,
McAvoy.
Judge McAvoy.
She says in her, I think this is hers, the affidavit. She's talking about that original in limine.
Yeah.
The further stated that Tipton believed that any transmittal or recording of the defendant's image posed a significant threat of physical and emotional harm to the defendant. And that's why I asked whether, what was that based on the evidence at the McAvoy hearing, because the affidavit that was filed in support of the motion at the time in 2000 talks about both the image and the facts.
Yes, I think she also draws on the trial transcript evidence of when Judge Barton was hearing that motion and when Attorney Tipton argued that motion, that it was because of fear. He didn't want his image being broadcast back to those who with that information, could then threaten him again. That puts it in context that he's scared of next day dissemination of his image in the media and getting back to other inmates, not 2 years down the line, folks watching BBC programs and ultimately those watching PBS.
Well, I mean, it strikes me we've been talking a lot about the filming, and I don't see that the filming is neither here nor there. The judge was acted perfectly appropriately in allowing the trial to be filmed. We certainly encourage open trials. We allow cameras in the courtroom with certain limitations to protect witnesses occasionally if there's a good reason, and jurors. The question really here is whether there was an agreement by the defendant to permit his conversations with his lawyer to be tape recorded, right?
That's exactly the issue.
That's it. It's a very narrow issue, I think.
And we have a clear finding of fact by Judge McAvoy on that, which I assume is supported by the evidence at the hearing, which is Tipton testified that the defendant had extensive conversations regarding the microphones, right? The problem with that is it doesn't say what the content of those was. Was he agreeing to them, not agreeing to them? Was Tipton saying, look, we've lost the motion, so we've got to have the microphones, but let me tell you, we can turn them off? I mean,
Yes, Your Honor, that is the difficulty.
what did Tipton say was the content of those communications? We've lost the motion, so here's how we're going to protect ourselves, or...
There's nothing to indicate that was what was discussed, that because of the motion is out, that this is something you can't do. I think what Attorney Tipton did reiterate over and over again is I told my client I could turn this mic off whenever you say. He basically reiterating over and over again, Lee, this is your call. If you want this off, I'll turn it off. And at one point, there was a microphone where it's just a button. The second microphone the attorney used, you had to unplug the jack. Whenever you want, you say the word, I can do this. Or we can use the pen and paper, or we can talk after the proceeding. I would argue that some of the evidence that would be very helpful today wasn't elicited at the evidentiary hearing because of hearsay reasons. The exact details, he said, I said, he said, I said, didn't come out. It was more a testimony of, did you describe the situation? Yes, I did. And he still wanted to go forward.
Well, is it clear that the attorney agreed to wear this microphone, agreed with Lyon to wear this microphone? That's where this Downey case, the case that establishes this as a conflict of interest. If an attorney agrees to wear a microphone at a trial, that'll pick up attorney-client conversations without the client's knowing consent to that. Was there an agreement here between Tipton? Between Tipton and Lyon, the production company?
I wouldn't characterize the agreement between Lyon and Tipton. I would characterize the agreement between Lyon and the defendant in this case, because when first approached by Lyon, Attorney Tipton basically articulated, this isn't my call, it's the defendant's. It's always the defendant's, and he kept, as he learned more information from Lyon and from the court, he went back to his client and informed him in greater depth. At one point, both Attorney Tipton stated that both he and the defendant wanted more information. They sought that information. He brought it back to the defendant. And attorney's testimony, to his credit, is that he conveyed all that to the defendant, and the defendant made a choice. So I would characterize the agreement as one between, although they didn't speak face-to-face, as the court pointed out, was between the defendant and Lyon to allow his attorney to wear the microphone. It's quite analogous to...
So you're saying that Tipton was negotiating an agreement between Perkins and Lyon?
Yes, Your Honor. Maybe not even an agreement. Maybe just a situation that could be terminated at any time. Just an allowance to wear this microphone as long as the defendant allowed. It's analogous to bringing someone to an attorney-client visit. It prevents the formation of this attorney-client privilege. If I brought someone with me, a third party, in this case, if I brought Lyon with me when I sat with my attorney, it would be my consent, although it's somewhat different facts because Mr. Perkins was never approached by Lyon because he was incarcerated at the time. The situation still holds true that it was always within the control of the defendant to bring in this third-party Lyon.
Did Tipton ever tell Lyon that Tipton understood that he would benefit from this because he would get some public exposure?
No, he didn't. In fact, he adamantly, from start to finish, refused to grant an interview to Lyon, wherein, over his advice, the defendant did choose to do so. So the attorney Tipton, there's no evidence that he benefited at all in this situation. He was clearly concerned of the potential consequences, articulated those to his client, and he stayed away from one-on-one interviews and more than was necessary than his client consented to.
Did he recommend against it?
In express language, it's not in the record that he did. He says something to the effect of, against my advice, Lee did sit with the Lyon on a one-on-one interview.
I think, Mr. McGowan, and it may be that there's enough here to say that there was an adequate waiver. When I asked Mr. Shea, did he agree? I mean, what I meant was, I don't know whether that's legally adequate because he the defendant clearly agreed to plenty along the way. The question is, why would an attorney even take a suggestion to a defendant that highly confidential? I mean, how is the client to know, turn that off? I'm not going to say something to you. I mean, it's usually when the client wants to bring somebody, in your hypothetical. I think what's troublesome here, and I think the gist of Justice Spina's questions are, for Tipton to say, let me lay out all the disadvantages. Well, he can lay out all the disadvantages, but the most important thing is he should be saying, I'm not even going to take this to my client. Yes, you can film, and I may agree to be, on the list, but even to take the idea that you would sort of get consent to have somebody film the micro, it's very hard for the client to know what the full ramifications of that are, surely.
Yeah, and usually when you see a microphone, for instance, at a district court proceeding, where the proceedings are being taped, if there's a microphone at counsel's desk so that everything can get recorded as counsel speaking, if the lawyer's turning to his client to engage the client in conversation, you always see the hand going up and covering the microphone. That obviously didn't happen in this case.
No, it didn't. While it might not have been, the defendant had a right to know of the offer, and the attorney brought him to make sure that the defendant was fully aware of everything in this trial. It was attorney Tipton, I would argue, to bring that invitation.
Why did he have to know of the offer? I mean, there was no benefit to the defendant.
Well, I would say if the attorney didn't tell the client, the attorney would be criticized for not sharing information about something that a client ought to have a final say on. So I don't have a problem with that.
Mr. McGowan, I think the problem here is whether the client understood that there was a difference between face and the recording, between confidential and not confidential. And we'll just have to look at the record for that.
There were no
Yeah, it isn't a question. I just want to be sure before everybody leaves. Mr. Shea, you are pursuing all the arguments in your 2003 brief, are you not?
Yes. Time prevented me.
That's fine. I just want to be sure.
And I assume the Commonwealth is doing the same, correct?
Yes, we are, Your Honor.
Thank you, Mr.
Thank you.
McGowan.
Thank you.